Welcome to another episode of What Does the Law Say? Before we move on, please like, share, subscribe, and drop your comments in the comment section. Thank you. Yes, sir. Flowing from the first question that we answered, in the event that the employee ensures that, okay, yes, these are the terms of the contract, this is what I want, everything is just as I want and just as I've agreed, and they sign the contract. But, along the line, probably 1 year into the employment, the employer is not fulfilling the terms of this contract. Maybe things like the work hours or the payment of his salary. I've heard people say that they are working and they've not paid them salary for 6 months, and they don't work for the government. So we can't say that there's an issue or there's a reason why their salary has been delayed. So in this instance, how does that employee enforce this contract? Because now they have a document, they have a written contract. They probably do not want to go to court. They don't want to have any conflict with their employer, but they also want to make sure that what I signed is done. I have all that I've agreed to. So how does this employee move on from there?
Okay, so in order to do that, it's a bit dicey if you are still in employment.
Okay.
But let me pick it from the aspect of the payment of salaries.
Okay.
Is it stated when the salary will be paid?
Okay.
If it's stated and it's not being adhered to, are there communications why it is not being adhered to? Now, because how you can enforce such is to write a petition to the National Industrial Court to enforce the terms of the contract. But you must be able to confirm and establish beyond all reasonable doubt that the employer is not keeping to their terms. So imagine the employer had told you that salaries would be paid in arrears and there are no dates stated. At the offer letter, it may not be stated, but in the employment handbook, the employee handbook, it is expected that it will be stated that salaries will be paid before X dates. For forward-looking organizations that we've actually helped to design HR policies and employment handbooks, they state your salary will be paid by the 25th of the month.
Yes.
They go ahead to tell you if the 25th falls on a Saturday or on a Sunday, then you will likely get it the Friday, the day before the week or the day after. If that date falls on a public holiday, federal government declared public holiday or Lagos State declared public holiday, they tell you you're likely to get it the day before, the day after. That's for forward-looking organizations.
Yes.
Because they are clear, there is nothing to hide. But when that is not stated, it's a conversation that you will need to establish that it was not stated. Because if the employer can tell you, we never stated. Remember that employment laws in Nigeria is at will. The employee has the right to continue to be in employment or to take a walk. Because of the danger of victimization, most employees will not say anything. They only go on social media to rant.
What can they do?
If you are logical as an employee, you need to ask yourself the question, is this something I can live with?
Yes.
Unfortunately, there are laws to guide the employee, but in Nigeria, unfortunately, we are not there yet, where you can still remain in employment and there will be a litigation going on in courts. Because there are cases, most cases we've had where the employee actually goes to court are cases of termination, unjust labor practice. They terminate their employment and they go to court to contend it.
Yes.
Now, in that situation, you are not afraid that
because
there will be
it's over.
Victimization.
Yes.
You're only fighting for your rights. But there are times when you're in employment, all you can do is to appeal. If there's a labor union, fortunately, then the labor union will be the best place to go. But in situations that happens, there needs to be a communication from the employer to the employee on why are we not paid.
Yes.
Then there's also the aspect of choice. You can walk away.
But they want to go with their money. They want to go with their salary.
So, if you are courageous enough,
yes,
you walk away, document your salaries were not paid, then put a petition in.
Okay.
Because at that point, you can actually now owe them because you have evidence that your salaries were not paid.
Yes.
There are evidences that you have followed up and there were no responses.
Yes.
So at that point, you now have enough proof
Yes.
to show that the employer owes you for work done. Because at that point, you can now choose to go to the industrial court to enforce the terms of the contract.
Yeah.
Or if you're a bit fortunate as an employee, get a lawyer. Tell them
That's
to
always
send
the solution.
Tell them to send a worded email
Yes.
or a worded letter to the employer.
Yeah.
Because for some employers, they understand that the employee has rights. Because if that case gets to industrial courts and you're able to establish that you have a cause,
Yes.
that this is unjust labor practice, most of the time, you can count the numbers of cases in Nigerian industrial courts. It favors the employee at the end of the day. But remember our judiciary system.
Yes. We cannot forget that. Actually, I mean, from what you said now, I can pick out that as an employee, you must arm yourself with your employee code or whatever it is that your employer has given to you, to ensure that, okay, this is what is required in my organization, this is what is expected in my organization. What happens in organization A might not happen in organization B. So some people's workplace, they say they will pay their salary on the 25th. Some people pay on the 22nd. Some people pay on the 30th. But you want to make sure that you've read it through too. You're not being cheated in any way. And I think employers too also must have that empathy.
Yeah.
Where if something is going on in the organization and is holding some things back, is stalling things, you want to inform your employee, I'm sorry, this is what is happening, we would rectify it and we'll move on from that. And I'm sure that if it is a good organization, just like Mr. Akiode said, they would definitely do all that is necessary and inform you, communicate with you, just like he said. So make sure that you understand the terms of your contract, you read through it, and also you read your employee's handbook to ensure that you are informed about all your rights and all the obligations of your employer. So, Mr. Akiode, I would like to ask you this question. I've heard instances or examples and stories of people that were working at organization A and then got an employment offer, got an employment opportunity at organization B. And they didn't want to leave organization A, but because of a better salary, you can commute to organization B better, you decide to leave your organization A and join organization B. But then you do that after getting your employment letter or offer from organization B, and then they tell you the day you're about to resume that we're sorry, we don't need your services anymore. Meanwhile, the person has already resigned from organization A. Is there any compensation for this employee? Is there anything that the employer is required to do? Because it seems like he has lost on both ends.
Okay, that's an interesting question, and it's not strange.
Okay.
Strange because we've had opportunity to maybe directly or indirectly advise individuals that fall into that category of what to be done.
Yes.
Let's go back to the basis.
Okay.
Now, your employment contract for organization B, does it meet the requirement of what an employment contract should have?
Okay.
Is it signed?
Okay.
Do you have evidence to show that you are required to resume as X dates?
Okay.
Now, if you have all of those checked, the next conversation is to say, technically, from the day you signed that offer and expected to resume in 2 weeks, you are already a staff of organization B. Because there is always a clause in every offer around what we call the probationary period. At the minimum, what organization B is expected to do is to activate the probationary clause. Probationary clause is always in every employment offer.
Okay.
And it goes that if my probationary period is 3 months or 6 months, an employee can resign, giving 2 weeks notice or salary in lieu of notice.
Okay.
The same for the employer, meaning the employer can terminate that employment, giving 2 weeks notice or salary in lieu of notice, depending on how it is worded in the employment in the probationary clause.
Okay.
technically, the employer should abide by that clause. So at the barest minimum, employer B is expected to give compensation to the employee, because it is not the employee's fault that they don't need that service anymore. You have a legal case on employer B to enforce that clause that you are expected to compensate me based on this, and you did not do that. So it means you can actually go for litigation.
So the issue would not be whether there is any work done at all, as long as he has signed that.
Let me say the way out for the employee is that probationary clause. Because the probationary clause says I resume, and I'm not yet a full-time employment until 6 months. So technically, from the time I sign the offer till the day I'm expected to resume, it is already assumed that there is an implied contract that is in motion. Because I've resigned from the former employer. An employee cannot have 2 employers. So technically, I am your staff. I'm only waiting to resume. So my probationary period has started from the day I signed the offer of employment, irrespective of when I've resumed or not. So the barest minimum of compensation to the employee for the employer caught stopping the resumption is at best, give me my probationary clause termination. What does that probationary period say? Give that to me, and I'm sure that, yes, I can go back to the labor market. So if you really want to go for litigation, the barest minimum you can get is that amount. And if we can establish unjust labor practice, the employee may be able to get as much as 4 times the annual pay. If the case is well prosecuted, you can get as high as 4 times your annual salary if you go through. But the most important thing is being sure that there are evidence to show that I had the physical, because there was a particular case that was lost in transit simply because that employee never had a physical copy of his agreement of employment. We got him a litigation lawyer, an employment law lawyer, to handle the matter, but the lawyer said the major problem they had was that he only has email communication that never had letterhead. That was never signed, or the offer letter, the pre-offer letter, and on that basis, the employee went ahead to resign. So the employer knew what they were doing. The employee did not cover his own basis, because if the employee had a physical offer letter, the case would have been a sweet case to handle. But you know, most of the time, people don't follow through. These cases are bound, and I can tell you, even within this current economic COVID-19 situation, induced situation, there are employers that have withdrawn offer letters without communication to the employee. Because they feel that nobody is going to say anything. But these are cases that sometimes we hope that there are lawyers that can do pro bono and actually
help you.
Because immediately there is a precedence on cases like that, employers will stop doing it. But I'm not sure whether there have been any precedent that have been taken to a logical conclusion, so they continue to take. So just use that gap in the system. But it's really, really wrong. It's not fair on part of the employer. At the minimum, they should be able to give a sort of compensation. But because the Labour Act and other employment acts may not really give evidence, the best we can work with is the contract of employment. And be able to prove that there is a probationary period. And from the time I signed, that probationary period actually is in force. I can prove I'm no longer in the other employment. So I'm only waiting to be your staff.
I mean, even moving from what you said, it has also pointed out that simple paying attention to details. Does the mail, they've sent me, or the employment letter, does it have the letterhead? Does it have this? Does it have the signature? Simple things like that, can help you when bigger issues arise. And I mean, employees sometimes, from my own perspective, don't want to, don't want to move any forward because they just feel like, well, that one has happened. Let me go ahead and look for another job. But then I think it's on the part of the employer to ensure that they just do something for the employee, no matter how little, 5% of the salary, something.
But it's critical that it's important that I had that forward-looking organizations do the right thing. But if we do an analysis of the Nigerian employment market, you would realize that most of these issues, you will not see them in multinationals because they are driven by ethics. You will not see them in big Nigerian conglomerates because they know that they are publicly quoted. The backlash can be more on the investors and the rest. You see them more in SMEs. You see them more in organizations that you look at what is going on and say, who's going to take me?
Who's going to disturb me?
Who's going to disturb me? Because they're flying low, below the radar. Yes, there are one-offs of organizations. Scenario I cited of the employee not being sure that all of the little basics were there. The name of the organization was not cited. But from experience, most of the issues we've had in this category don't happen to known organizations. Known organizations that the reputation of the organization will go down if it even goes to litigation. So, and the way the Nigerian market is, there are a lot of employers. I can tell you for free that 70% of employers in the Nigerian market play in the SME space. They are Nigerian-owned companies. They are not big conglomerates. They are not multinationals. So these things go unnoticed because nobody wants to take it up. We only get them in pockets when people come up to say them. But it's critical that forward-looking organizations are ethical in the way they do things. So it's now both ways. It's a point of the employer doing the right thing and the employee making sure the right things were done. Because now that becomes your evidence if you choose to go for litigation.
I hope we've been able to learn something as regards that, as an employee, if you ever find yourself in such a situation, do not immediately just say, well, that's how the Nigerian market is and that's how employers are. You can go ahead to, seek for the compensation or ask for the compensation. And, the employers too should make sure that on their part, they do all due diligence. Don't just decide to employ people in their thousands and then, just push them out, throw them out without no reason and just say, I'm sorry, we don't need your services any longer. So ensure you do your due diligence as an employer and as an employee. Thank you very much for watching today's episode. I hope you were able to learn something. So this episode is broken into series. Watch out for the next series next week. Please like, share, subscribe, and also drop your questions in the comment section. If you'd like to follow Mr. Segun Akiode for any other explanations or you want him to answer any questions, or you also like to learn more about HR and capacity development, you can follow him at Segun Akiode on YouTube. You can also check out in the description for all other links to follow Mr. Segun Akiode. Thank you. See you next week.